So hello, I'm Vinayan Singh, and I'll be talking about law of bail in our country. So for the next 20 minutes, we'll be focusing on the object of bail, bailable and non-bailable offences, procedure of bail, and the relation between bail and poverty. Object of bail. It was held in Sanjay Chandra versus CBI and Remembrancer of Legal Affairs versus Amiya Kumar that law of bail has to dovetail two conflicting demands. On one hand, the requirement of the society for being shielded against the hazards of being exposed to people who are accused of crimes, and on the other hand, the fundamental canon of criminal jurisprudence that is presumption of innocence until proven guilty. Hence, the law of bail is based on the principle that if the presence of the accused at the trial could be reasonably ensured otherwise than by his arrest and detention, it would be unjust and unfair to deprive the accused of his liberty during the pendency of trial. Bailable and non-bailable offences. The Code of Criminal Procedure has classified all offences into bailable and non-bailable offences. According to Section 2A of CRPC, bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. And non-bailable offence means any other offence. If an offence is bailable, bail is mandatory and is a matter of right. When the offence is non-bailable, bail depends upon discretion of the courts that is guided by several considerations which would be further discussed. Bailable offences. Section 436 of CRPC deals with bailable offences. According to this section, any person accused of a bailable offence should be released on bail. Further, Section 50, subsection 2 of CRPC makes it obligatory for the police officer arresting such a person to inform him of his right to be released on bail. This section also provides that if the court thinks that the accused is indigent and is unable to furnish surety, he can be discharged on a bond without sureties. It is further explained in this section that if a person accused of a bailable offence is unable to give bail within a week of his arrest, it shall be a sufficient ground to believe that the person is indigent. The amount of bail. In Swaran Singh Gulshan versus Collector of Customs, it was held that the right to be released on bail under Section 436 cannot be nullified by fixing too high amount of a bail bond. Section 440 subsection 1 specifically provides that the amount of very such bond shall be fixed with due regard to the circumstances of the case and must not be excessive. Further, Section 440 subsection 2 empowers the High Court and the Court of Session to issue direction for the reduction of amount of bail. In Dharmu Nayak versus Ramandranath Acharya, it was held that the refusal to grant bail in contravention of Section 436, that is in the cases of bailable offences, will make the detention illegal and the police officer causing such detention would be guilty of wrongful confinement under Section 342 of the IBC. Non-bailable offences. There are two sections that deal with non-bailable offences. The first one is Section 437. Section 437 empowers the magistrate to grant bail, but this section imposes certain restrictions or a bar in some circumstances. For example, if there are reasonable grounds to believe that the accused has committed a crime punishable with death or imprisonment of life, the bail shall not be granted under this section. The second is Section 439. Section 439 deals with the power of High Court and Court of Session in granting bail. The High Court and the Court of Session enjoy wide powers in matter of granting bail, in matters of granting bail, and there are no restrictions or bar like those on magistrate as mentioned in Section 437. But there are some overriding considerations that have to be considered while granting bail. Considerations in granting bail. It has been held in Rao Harnaren Singh versus State and reiterated in Sagri Bhagat versus State of Bihar, Gudi Kanti versus Public Prosecutor, and Gurcharan Singh versus State that the law favors the allowance of bail, which is the rule, and refusal is an exception. A combined reading of several cases on bail, especially State versus Captain Jagjit Singh and Gurcharan Singh versus State, provides hits us with two paramount considerations. First, the accused will not abscond, and the second, that he will not tamper with the witness. Other considerations include the enormity of the charge, the nature and seriousness of the crime, health, age, and sex of the accused, position of the accused in reference to the victim or the witness, history of the case, etc. Now, another important topic is anticipatory bail. Section 438 deals with the provision of anticipatory bail. This provision was not presented in the old CRPC and was inserted on the recommendations of 41st and 48th Law Commission reports. This section talks about a provision for pre-arrest bail. The Court of Session and the High Court are empowered to grant anticipatory bail if they are satisfied with the reason for apprehension of arrest. It was held in Suresh Vasudev versus State that there should be reasonable grounds for the belief of arrest, and mere fear is not belief. It should not be any vague apprehension and must be based on reasons that could be examined objectively by the courts. Apart from this, Section 167 Apart from this, Section 167, subsection 2 provides with the provision of mandatory or default bail. That is, if the charge sheet is not filed within 60 or 90 days, it depends upon the nature of the crime, the accused has the right to be released on bail. There is a close connection between law of bail that is today in a society and poverty. It has been held in Kadra Pahadia versus State of Bihar that it is a crying shame on our adjudicatory system which keeps men in jail for years without a trial. It was held in Motiram and others versus State of MP that social justice is a signature tune of our constitution, and the little man in peril of losing his liberty is the consumer of social justice. The grant of bail can be impossibly be inconvenient and expensive if the court is powerless to dispense with the security to receive an Indian bailer across the district borders, or the sum of bail is so excessive that to procure a wealthy surety may be both exasperating and expensive. The problem is plainly one of human rights, especially for the lowly, that requires the Supreme Court to interdict judicial arbitrariness in relation to liberty and ensure fair procedure, which was a creative connotation after Maneka Gandhi case of 1978. If we talk about this case, Motiram case, it is a case of 1978. In this case, the accused was a poor mason. The Chief Judicial Magistrate had fixed an amount of rupees 10,000 as a surety, and 10,000 in 1978 meant a very big deal. And for surety, he was refused to allow his brother to become a surety as his property was in the adjoining village. Motiram went to the appeal in the apex court, and Justice Krishna Iyer condemned the act of the Chief Judicial Magistrate and said that the judges should be inclined towards bail and not jail. In Maneka Gandhi versus Union of India, Justice Krishna Iyer once again spoke of the unfair system of bail that was prevailing in India. No definition of bail has been given in the code, although the offences are classified as bailable and non-bailable offences. Further, Justice P.N. Bhagwati also spoke about the unfair and discriminatory bail system when looked at from an economic criteria of a person. This discrimination arises even if the amount of bail fixed by the magistrate isn't high for some, but a large majority of those who are brought before the courts in criminal cases are so poor that they would find it difficult to furnish even if it is a small amount. The Honorable Supreme Court has given several judgments which in which the consideration to economical condition of the accused has been made mandatory. For example, in the case of Keshav Narayan versus State of Bihar, the condition imposed by the High Court was that he should furnish security for rupees 1 lakh in cash or fixed deposit, and with two sureties residing in the state of Bihar, and it was held by the Supreme Court that it was a onerous condition. Our judicial system is beset with massive problems of delay, cost ineffectiveness. There are around 2.5 crore cases pending in district court across the country. This has led to the ineffectiveness in the working of the judiciary, and more often court fails to implement the crucial provisions like that of bail. Thus, inmates who have been accused of committing a petty criminal offense have to languish in custody for years. They have no other option but to face prolonged investigation and delayed trials and tortures. Further, in Husainaira Khatun versus State of Bihar, the court laid down the ratio that when a man is in a jail for a period longer than the sentence he is liable, he should be released. One of the important issues is the lack of awareness. It is perhaps the first hurdle that needs to be overcome if the bail system is to be improved in any capacity throughout the country. One of the most common reasons as to why there are so many under trials is the lack of awareness of legal rights. Article 39A of the Constitution says that the state has to provide free legal aid to people who cannot afford it due to economic conditions. In the case of Dinesh Bhai versus State of Gujarat, the court referred to Article 39A as the guiding star and said that it can hardly be disputed that legal aid is among the most basic fundamental right of the citizen. Further, Section 436A of the Code of Criminal Procedure indicates that the prisoners who have spent more than half the minimum time allotted for that crime shall be released on a personal bond with or without sureties. However, this knowledge is not known by majority of prisoners who are in jail, and thus they are under the impression that they do not have any legal recourse. This situation this makes the situation worse for those who are heavily affected by poverty, as they have nothing to rely upon. Significant portion of people in custody are entirely dependent upon the courts, prison officials, and jail visiting lawyers. To conclude, I would like to say that it's high time that progressive reforms should be made in the provisions of bail.